The last two elements that I'd like to look at in this unit: cyber insurance and work product protection. Settlements and adverse verdicts and trials can be very costly to a company. So many companies look to cyber insurance as one means of covering those costs. You could be general liability insurance, riders covering cyber events, errors and omission insurance, or specialized policies covering cyber events. Insurers may go to court to challenge companies' attempts to get coverage for data security breaches under their policies. And they're divided over a point called publication. Some courts conclude that any data breach constitutes publication of personal information and should be covered under commercial general liability policies. So this brings up the case of Travelers Indemnity Company of America versus Portal Healthcare Solutions. The customers filed a class action lawsuit against Portal. Portal had been breached and exposed medical records. Travelers argued that exposure of the data was not a publication of the information, as Portal had no intent to publicize that data. The district court ordered Travelers to pay Portal, as a distinction between intent and no intent by Portal was irrelevant. The Fourth Circuit Court agreed. Other courts, on the other hand, have ruled in reverse of this decision. They ruled exposure was not a publication that triggers insurance coverage, so ended up not having to pay. Since coverage under general liability insurance is uncertain, companies seek coverage under supplemental cybersecurity insurance policies. There's coverage for a wide range of cyber-related events. One company is Cybersecurity by Chubb. It's mentioned in the textbook. It's a flexible insurance solution designed by a cybersecurity expert, and it covers a broad spectrum of risk: disclosure of private information, copyright and trademark infringement, reputational injury, systems security failures harming third parties, injuries as a result of system outages. Cybersecurity by Chubb also had direct costs as well, like direct data breach notifications, crisis management of the data breach, forensic consultants, online vandalism, and all kinds of things that might have been related to that data breach. In P.F. Chang's breach in 2016, over 60,000 credit card numbers were stolen. They paid $134,000 a year in premiums. Chubb covered $1.7 million in costs to P.F. Chang for the forensic investigation and defense of consumer lawsuits, but they refused to pay $1.9 million that was assessed by the credit card company as fines and card reimbursement and replacement costs. The district court ruled that credit card fees do not include as private industries that insurance was designed to cover. So the court noted that the restaurant was a sophisticated party, and if it wanted these fees to be covered, it should have bargained for them. You must carefully determine what is covered under provisions of your policies. Bargain for all the costs of a cyber event to have it included under your coverage, and think about what those costs might be. Certainly, fines and fees and replacement costs from a card companies will definitely be part of those fees, and they can be very large. An alternative to an insurance policy is self-insurance. It requires a large reserve of cash to be put aside. In the case of P.F. Chang's, they would have had to have put $3 million aside, which for many companies may not be a large amount of money, but it still is money that you can't touch. It's in reserve. On the other hand, if you think about it, $134,000 a year for the premiums, I could pay that premium for 22 years before I cover $3 million at the breach cost. And by only paying the premium, I can reinvest a lot of that other money, or use it for operation of the company. And even if to have the additional fines and fees covered under the policy may have raised the policy to $150,000 a year, let's say, that's still 20 years I could pay premiums before I would reach the $3 million cost of the breach. So you need to think out that process. Do I do a reserve and just self-insure? Problem with self-insurance is you really don't know how much a breach is going to cost you. Protecting your work product is a very important aspect of handling a breach, particularly in breach litigation. We talked about the discovery process and how opposing attorneys and clients can come to you, your attorneys, and ask for very specific things. All the communications that were relevant to our company, or whatever. And when you think about it, we normally communicate with each other within the company through messaging and email, and that's all recorded. So it's all subject to litigation, subject to discovery. When litigation begins, the legal department will issue what's called a litigation hold or a lit hold. This establishes an unequivocal preservation order. What does that mean? That means you cannot delete or erase anything relevant to the case. If you do, and somebody finds out, that can result in some very serious fines. Could end up in even worse than that. But the litigation hold will ask for very specific material, such as emails, instant messages, notebooks, printed material, drawings, anything that the attorneys can imagine that will be relevant to the case. And they may define where and how to store material that's identified by personnel in the company. In addition, we may hire professionals to assist in various aspects of the investigation, such as attorneys, digital forensics experts, security consultants, etc. All material concerning the case is discoverable. However, there's ways to protect some of that, and attorney-client privilege is a very important one. This protects from discovery communications between the attorneys and their clients, and that could be the legal department and the employees of a company, while seeking and providing legal advice. And it's nearly absolute. So as long as we're discussing how to proceed with a case or what to look for, maybe the attorney might say, hey, go look out in the logs and see if you can find anything on the report. Anything that you can report to us that might be relevant to the breach. The attorney-client privilege protects communications, but not the underlying evidence. So in that case I gave you, my communication or my report back to the attorneys might be attorney-client privilege, but the logs that I'm using to gather that information is still discoverable. It covers legal advice, but not legal business advice. And the third-party communications may or may not be covered. The best advice I can give you on attorney-client privilege is talk it over with your legal team. How would they like to proceed in the security and litigation hold if it occurs? They'll issue normally that email to everybody involved, and then. But, are they going to want you to gather the data and put it someplace? Do they want to establish a electronic repository? How do they want to proceed if they do find or if they do have a litigation hold? Work product doctrine is more likely to cover the security work performed under direction of the attorneys. And again, it's not absolute, but it is a very important aspect of the litigation process for you. Federal Rule of Civil Procedure 26b3 says that a party may not discover documents and tangible things prepared in anticipation of litigation or trial or for another party. So what I'm saying here is that if I build a report that shows how a breach may have occurred, I can send that to my attorneys in the legal department, and it probably should not be considered discoverable. There's no absolute, though. The opposing attorney may argue it has a substantial need for the materials, or the court may find a good cause to allow discovery of the work product. The consultant's work product may be covered as a work product in this case if it's prepared in anticipation of litigation. Non-testifying expert privilege is a very narrow privilege, and it basically says that opposing attorneys cannot discover facts known or opinions held by an expert who's retained or employed to prepare material in anticipation of litigation and is not expected to be a witness at trial. And again, there are some exceptional circumstances that the opposing attorneys may present that could actually make that information discoverable. In the Genesco versus Visa case, Genesco is a retail chain that was hacked, and their general counsel hired Stroz Friedberg in anticipation of potential litigation or regulatory proceedings. Stroz Friedberg does forensics and security consulting and a number of other things to assist in breaches or in understanding forensic information, digital forensic information. Visa investigated Genesco and issued $13 million in fines and reimbursement settlements against the banks that backed Genesco. And this is a very common practice. The Visa or MasterCard will issue the fines to the banks that back the company that's collecting credit cards, and as in this case, Genesco had an indemnification agreement with the banks, again very common, which basically the bank said, hey, we have a fine from Visa, you need to pay us $13 million. Genesco then sued Visa. Visa subpoenaed Stroz for deposition testimony. In other words, they wanted to get recordings of and written testimony of individuals that worked at Stroz who worked on the case and work product of the investigation. The court largely rejected Visa's argument, considering Stroz as a non-testifying expert witness, and Visa did not establish those extraordinary circumstances that were needed to allow that exception. Genesco also used IBM to help define some security measures that needed to be put into place. And that was also considered work product, as it was consulting and technical services to assist the attorney in rendering advice. That was protected by attorney-client privilege as well as the work product doctrine. That concludes Unit 2 for this week.